All right, I'm back with David Azizi from the law offices of David Azizi, and we're going to do something a little different that nobody else has done. We're going to have a little bit of a discussion as it relates to personal injury in a case that David was part of. And we're going to use Google Plus as the discussion board, and I'm going to share it a few times and see anyone with a brain can contribute to this discussion because it's from the perspective of a juror. You know, if you were on a jury, how would you feel about this certain situation? So David, take it away, explain the case, and explain what type of discussion you want.
Okay. Well, as lawyers, we're always interested to know as to if this case went before a jury, how the jury would think about this case, and would they side with the plaintiff's side, would they side with the defense side. And as lawyers, we've always found out that there are issues that lawyers themselves don't think about because they're so into their case and they're looking about the liability, the damages, that there's some outside issues that the juries actually take into consideration that lawyers don't take into consideration. And it's somewhat like considered like a focus group. You know, you present the case to the jury who's not the actual jury, but somebody else who could exactly be 12 jurors that would have the same viewpoint, same thoughts, to understand, okay, if this ever went to trial, how the jury would come back in terms of a verdict and decision making. So the case that we had or have is a situation where our client worked for Procter & Gamble, and their responsibilities and duties are to shelf the products on the shelf of this particular retail store. And the question is that one of the supervisors of the store came over to our client, who's not an employee of this retail store, and indicated to them, I want you to go ahead and help me move this pallet of Sunkist juices that are in a box of 10 from the back of the store to the front of the store. And one of the issues was that our client contended that none of these box items on the pallet were shrink wrapped. The defendants agreed and said, yes, it was shrink wrapped only halfway. So there's some contention of issue with regards to that. Their own policy of the retail store stated that they're not allowed to move any item within the store that is on a pallet that's not been shrink wrapped. And the reason for that is because if you have items that are loose, you know, you're transporting it, you're pulling, there's a potential for these items to fall or collapse. Our client, being a nice lady, said, sure, I will help, and she started pushing, and the store manager or supervisor started pulling the pallet. When they got closer to the front of the store is when all of a sudden the boxes fell down, and as our client is pushing, a few boxes fell on her and a few boxes caused her to trip and fall. She landed on her knees and elbows and sustained severe injuries. At the time of the incident, she felt embarrassed about the whole thing and said, you know what, I'm okay. I think I'm okay. All right, fine. I'll go back to what I was doing. Now, the retail store's policy and procedures are that when an incident occurs, irrespective of injury, you need to document the incident. You need to preserve the videos. And part of the reason for that is, as their own policy is that you want to later on, if you ever want to refer to this incident, in case our client or somebody else says something different, you have documentation of it. You have a video that you can review and see. Well, this retail store, for some odd reason, I don't know why, but never did preserve a video or write up an incident report that, for example, this is how many boxes fell down, or our client said she's okay or she's not okay. So that was one of the issues that we had with the case. And unfortunately, as a result of this case, our client was diagnosed to be a surgical candidate, but because she had underlying problems that made her a high-risk candidate for surgery, her doctor had said, I wouldn't recommend you going through it because, God forbid, if you do, you may never make it out. So our client, who's in her mid-60s, is now going to have to live the rest of her life in pain, and just the only source of treatment she has is pain management, and the cost, I think, was somewhere about $7,000 to $8,000 per year, also $3,000 to $4,000 a year for pain medications. On top of this, she also had what they call fibromyalgia, which is a nerve injury that came about subsequent to this accident, which is an entire body pain that she suffers. So the question we have from everybody out there is, based on this fact scenario, would you find the retail store at fault? Would you find our client at fault in any way for comparative fault or assumption of risk, assuming the risk of pushing this pallet, knowing that it's not shrink wrapped? Is there any fault on our client in this particular incident? If there is, we'd like to know what the percentage of fault is between the retail store, and our position would be, well, the retail store is the one who's in a better position, knowing that it's not shrink wrapped. They have more experience in removing a pallet, in understanding as to whether they have full 100 responsibility, or does our client share some responsibility. Then the next question is as to whether, if you are to award an amount, what would you award for our client as far as damages? And what the other detail is that our client has had $65,000 worth of past medical damages.
And that's all. It's gonna be a great discussion, and we will do that on Google Plus. I will share that multiple times. There will be everything David discussed will be in a blog post, so you can read it if you're not going to watch the video. But that will be valuable information, and we'll definitely start the conversation on Google Plus and see how far this goes. It'll be an ongoing conversation, and I'd like to hear what you folks think. So thank you for your time, David.
All right, thank you.